I want to start by engaging Jessie Duarte. Now, Jessie Duarte, you will remember, had been quoted in the Sunday Times for saying that she really is not sure why it is that her comrade Tony Yengeni was punished so severely for something as routine as simply not actually managing to, remember to basically tell Parliament that he had been given a gift after negotiating a discount. And of course, she came under lots of criticism, including from me, for her comments that were reported on in the Sunday Times. And then since then, she has simply lost the plot. She's behaved like a bully towards my colleague Clement Maniatela yesterday. The only thing I can say, Clement, because Clement is still young, although he's excellent, that the way she treated you is not exceptional. She has been a bully for many, many years as a politician. So we sometimes say consistency is a virtue. Some people get that message in the wrong, convoluted way. Being consistently a bully is not exactly virtuous. And of course, she went on a rant about 702 and also about one Eusebius McKaiser. I had invited her to come on this show because obviously I'm not scared of her. She's a mere mortal, and she's been running for the hills from every single person that has invited her. She was invited to the Karima Brown show last night, made an excuse before talking her Karima's producer's head off, and then my producer had also invited her to engage her on her comments that were reported in the Sunday Times. And she said, I'm sorry, I'm not interested in speaking to you guys ever. Well, fine, I don't need to speak to you either. But what I will do is to describe to you facts that are inconvenient. So let's talk facts, since you don't like opinions. I think what you really don't like is not opinions, Jesse. What you really don't like are facts. So I want to go back to 2005. In 2005, Tony Yengeni attempted to appeal both the conviction and also the sentence of the fraud that he had been convicted of a little bit earlier in a lower court. And what did the Transvaal Provincial Division say in kicking out that attempt to appeal? They said the following, and I want you to listen very carefully. And please share this clip if you're watching this on the 702 Facebook page. Go and share it with Jessie Duarte. If you're friends with her, tell her very quickly to come to the wireless, although I suspect she's probably listening despite pretending that she doesn't really respect me. So here are some facts, Jessie Duarte, not opinions, some facts. The court had the following to say at paragraph 3. Before any preferred tender had been identified, Wurfel and the appellant, which would be Mr. Tony Yengeni, discussed a new Mercedes-Benz 4x4 motor vehicle that the former's company intended to introduce into the South African market. The appellant and the said Wurfel agreed that such a vehicle was to be supplied to the appellant at a discount of 47%. The documentation that evidenced the sale falsely stated that the vehicle had been acquired in terms of a car discount purchase scheme for companies associated with Daimler Chrysler or their staff and had been damaged during transport to the dealer concerned. This was the ostensible reason why the vehicle was acquired at a discount of such magnitude. Translation, for those of you who think that there is too much euphemistic speak, they lied. They pretended as if this wasn't just an extraordinary discount of 47%. It was that, and they pretended that this was part of some sort of damaged car that had been given to staff members that was now going to be given to one Tony Yengeni, who, of course, conveniently at this stage was in charge of the parliamentary committee that had the power to decide who was going to benefit from the arms deal. And then the court continues. Fact, Jesse, not opinion, fact. At 5. Word of the transaction leaked out. The appellant, who had failed to record the discount in the parliamentary records of benefits received by its members over and above their emoluments, denied the rumors. A public debate arose over the issue. The appellant denied having received an extraordinary discount in newspaper advertisements. And then this bit. After the truth came out, the appellant resigned from Parliament and he and Wurfel were charged with fraud and corruption in the regional court. After having accepted unsuccessfully against the charge sheet and having failed in a bid to have the dismissal of his objection set aside on review, the appellant changed his plea to one of guilty to the charge of fraud that he had been preferred against him as an alternative to corruption. Now, a little bit later on in the court record, some really interesting and important stuff happens. And I know that facts are inconvenient, Jessie Duarte, but I'm going to ram down your throat some important factual citations from this case. The court said the following about Tony Yengeni's behavior a little bit later. The appellant at no stage disclosed to Parliament or any of its committees, and in particular the committee he was chairing, that this extraordinary discount had been arranged for him by a company with an interest in the arms acquisition race. More particularly, the appellant deliberately and designately failed to register the benefit he had received in this fashion. In failing to do so, the appellant knowingly and consciously transgressed the Parliamentary Code of Conduct, which expressly required the disclosure of benefits of this nature. At all relevant times, the appellant could not have but appreciated that the acquisition of this vehicle in the aforesaid manner constituted a conflict of interest that should have been disclosed to Parliament, and in particular to the Joint Standing Committee on Defence. When the matter became public knowledge, Wurfel and the appellant attempted to cover their tracks by preparing, during October 1999, a backdated agreement of sale, falsely recording that the vehicle had been purchased by the appellant at a price of roughly 230,000 and that the appellant had paid a deposit of 50,000. In other words, they lied. They went so far as to take out several advertisements in the national print media, launching a strongly worded attack against the investigators. He falsely gave out that he had in fact paid for a damaged car, upon which he received a discount of 26%. Lies, lies, lies. He defrauded Parliament. But the two most important things from this case, and I want you to listen now very carefully. Two most important things come a little bit later. You see, when Tony Yengeni negotiated with the National Prosecuting Authority to have the more serious crime of corruption set aside, the agreement was that he will, however, acknowledge that he is guilty of defrauding Parliament. Now, when you do that, in your own name, you say the following facts are true, I swear by this statement, and then you sign the plea agreement. And we then take that to be a factually accurate citation of what you had done. Now, this is what Mr. Yengeni says he has done when he reflected on defrauding Parliament. And you can see here, if you're watching on Facebook, you can have a look there at this page. That is the most important page from this failed attempt to appeal his conviction and his sentence in 2005. For those of you not on Facebook, I'm going to read it out. You can see what's wonderful about this court record is that they even put the most important sentence in bold, which I'll come to in a second. So now we are not reading out the words of the court. The following is Mr. Tony Yengeni's own wording. Now listen to this. This is what Tony said. Jessie, factually, this is what Tony, your comrade, said. 1. I failed to register the said benefit and failed to disclose the receipt of the benefit to Parliament in any other way. My failure to disclose the benefit constituted breach of my above duties. He goes on to say, when information of the benefit became knowledge, accused number 2, that's Wurfel, and myself, Tony, we made the following misrepresentations in an attempt to account for my improper conduct. In other words, simple English, the guy is saying, I admit A, that I defrauded Parliament, and B, that I conspired to cover up my intentional defrauding. He goes on and he says, amongst a range of things, I falsely gave out that I paid a deposit of 50,000. I falsely gave out that it was a proper sale transaction in the normal course of business, and caused an advertisement to be published in the national press wherein I falsely attempted to give out that there was nothing improper. In other words, in his own plea agreement, Tony Yengeni tells the nation, and this is court record, that even the advertisements he took out in the print media were lies to cover his tracks. And then the most important bit that is inconvenient for Jessie Duarte is 425 of that plea agreement that Tony Yengeni had signed. And he says the following. The above misrepresentations were made with the intent to defraud Parliament. Now, I'm sorry, Jessie Duarte, there is not someone who forgot to tell us that they just got a gift, maybe a smoothie, when they came to Prime Media for an interview. There is someone who knew that they were subverting the Constitution, who knew that they were committing a serious economic crime, which is what fraud is, and that they intentionally went about to attack the investigators by falsely putting information in the public space in an attempt to cover their tracks. Now, you know what's also interesting, and this is the last bit from the court that I want to share with you, and this is not opinion, Jessie Duarte, this is fact. The court had the following to say right in the last page of this judgment, and this is really interesting. In the present case, a non-custodial sentence for the crime of which the appellant is guilty would be flagrantly inappropriate, given the aggravating features we have pointed out above. Certain misdirections are said to have occurred during the sentencing process in the regional court. Even if this was so, the imposition of an appropriate sentence was not affected thereby. So one of the arguments, guys, that Tony Yengeni's team made was, well, he's already resigned from Parliament. Surely the court should take kindly upon him because, after all, he's already lost his job. Now, this is how the court assessed whether a resignation from Parliament counts as a brave act. And I want every single MP to listen to this because many of you think that resigning is the gold standard of making amends in public. And this is what the court said about Tony Yengeni's resignation. It was urged upon us that the fact that the appellant had resigned from Parliament should be taken into account as a mitigating factor. The argument is a fallacy. The removal of a corrupt or dishonest official or elected office bearer from the position of trust occupied and abused by her or by him is not a punishment, and it is inappropriate to take such removal from office into account as a mitigating circumstance. In other words, resigning is not punishment. Resigning is not brave. It is the minimally decent thing you could have done. It is not a mitigating factor. And you know what I think is the most important part of the analysis around the non-custodial sentence that Tony Yengeni had hoped for, which he didn't get because the regional court didn't give it. They sentenced him to 4 years. The court finally, in the very last paragraph, second last paragraph, says the following. And how interesting is this, Sanele? And again, Jessie Duarte, inconvenient facts. The court says this at 75. We are of the view that the sentence imposed upon the appellant by the regional court errs significantly on the side of leniency. A sentence such as imposed in the Kwacha case would have been more appropriate. Now, let me translate that from the legalese into simple English. Number one, Tony Yengeni, by his own admission, committed a serious economic crime. Number two, by his own admission, he intentionally defrauded Parliament. Number three, by his own admission, he intentionally lied when he took out adverts in the national media to cover his tracks. Most importantly, the court said, your economic crimes are so serious. You are lucky that because we want this thing finalized, we are not going to give a new sentence. But actually, the 4 years that you were sentenced to were lenient, and the regional court, if anything, made a mistake, not by not giving you a non-custodial sentence, it made a mistake by actually being quite lenient on you. Now, given all of that, how can any ANC politician tell me that what he did was a minor infraction? And I think the conclusion here is very simple, that Jessie Duarte is not progressive. She's an enemy of black people. She's an enemy of the poor. And the only reason why she doesn't like opinionated people is because when opinions are anchored in factual citations from a court judgment, then it is inconvenient for a bully because it doesn't square with their lies to the public. 23 minutes after 9.
Joanne Joseph. Weekday